You need to be careful what you do. There is a fine line between zealously advocating for your client and doing something that either breaks the law, is unethical, that could get you in potential trouble.
On September 14, 2024, Cesar Moises Capriel Perez was arrested in Houston, Texas, for allegedly driving while intoxicated DWI. His case was filed in the Harris County Criminal Court a little over 2 months later. On November 26, 2024, Mr. Perez posted a $1,000 bail and was released from custody. However, trouble soon followed. On December 4, 2024, a bond condition violation report was submitted to the court, alleging that Mr. Perez had failed to comply with the terms of his release. Specifically, he had not installed a court-ordered ignition interlock device in his vehicle and failed to report to Harris County Pretrial Services, the agency tasked with supervising defendants out on bond. As a result, a bond forfeiture hearing was scheduled for December 10, 2024, before Judge David Fleer. At that hearing, Mr. Perez was represented by his court-appointed public defender, Noah Feldman.
Good morning, Judge.
Hey,
I just want the one thing I'll say. I have my client here on video. He can identify himself if necessary. I'm gonna just put my camera on. So
this is a first for me.
It's a first for the ICE supervisor I just spoke to as well.
Wow.
This is,
Wow.
I don't.
Mr. Feldman, that's some good work, man.
I'm
Great
an
job.
immigration attorney, Judge. So I mean, and I'm a salaried employee.
Yeah.
Really great job.
Order in the court, going on the record.
So, Mr. Feldman, what's the last name again?
This is Cesar Moises Capriel Perez.
Okay. You requested this hearing, so I'm going to let you start.
Okay, Judge. Well, before I start, I have 10 exhibits. I sent it to the chief last night, and I believe she forwarded it to Ms. Saba. I moved to admit those exhibits, tender them to the state for any objection.
And Your Honor, we would need significant time to look over these because we haven't been able to do so since they were.
Yeah, I have 10 exhibits. It's quite a bit.
Judge,
I get.
if I may. The first exhibit is the ICE detainer. It was in Harris County possession. The second exhibit is the magistrate order in which the state requested an $1,000 bond, which my client posted. The third exhibit is basically an ICE form you can get off the internet. It's a stay of removal form that ICE allows people with final orders of removal to apply for stays of removal that allow them to stay in the country for a limited time and limited purpose.
Is this his or is this just a generic?
Generic.
Okay.
Exhibit 4 is going to be just proof that he's in ICE custody. Exhibit 5 is the bond condition violation report. Exhibit 6 is from the DA portal, just showing the release time from the jail to prove that he was released to ICE. Exhibit 7 is the cash bond that defendant's wife posted. Exhibit 8, to be honest, is unnecessary.
Okay.
Could withdraw Exhibit 8. Exhibit 9 is a sample order of supervision you can get off the internet. It's just standard ICE form. And Exhibit 10 are this court's procedures that are available on its website about failure to appear and non-appearance. Those are the 10 exhibits.
So for purposes of the defendant, so record, I want to make it clear that Mr. Feldman has his computer and it looks like I can see the defendant there and it looks like he can look at us as well, but there's no translator. So does he understand what's going on?
That is correct, Judge. I do not believe he understands what is going on.
So now state, how do you respond to the exhibits?
Judge, I did not get these exhibits until my chief forwarded them to me while I was in docket earlier this morning. I'm going to need time to review these. I'm not an immigration attorney, so I'm unfamiliar with these documents. I would ask for at least a day just to, or I mean, if you don't want to roll it to tomorrow, just like an hour or so I can read through it.
Sure, of course.
I spoke to the ICE supervisor, Judge, the one handling his ICE case. His name is Jeff Hudson. I relayed defense's requests for an order of supervision, and the officer said, he declined the request. He said that there would be no way that they would release defendant, given that he is a flight risk, and his assault charge makes him a community risk as well. He also advised that the defendant has been deported before. He advised that the only way to get the defendant over to this court is if you issue a bench warrant, and then they would review that warrant and decide whether or not they would transport him over here, which is what I advised defense before.
It was later revealed that Mr. Moses Perez was being detained by U.S. Immigration and Customs Enforcement ICE to a possible immigration violation. During the court proceedings, Assistant District Attorney Roger Saba informed Judge Fleer that she had spoken with an ICE supervisor, who explained that the only way Mr. Perez could potentially appear in court was if the judge issued a bench warrant. In this context, a bench warrant is a formal order issued by a judge to secure the presence of a defendant who is currently in the custody of another agency. Essentially, because Mr. Perez was being held by ICE, such a warrant would serve as a request for ICE to transfer him temporarily into Harris County custody so he could appear before the court. However, Ada Saba clarified that a state judge does not have the authority to compel a federal agency like ICE to comply with such a request. The decision to honor the bench warrant would rest entirely at ICE's discretion, meaning it would be up to the agency whether to release Mr. Perez to Harris County authorities for his court appearance.
He also said that we can try to work out the possibility of the defendant giving a virtual plea, but in terms of them releasing him.
But we need a thumbprint. I need a thumbprint. I need his signature.
Yes, Judge.
There's no translator there for him now.
Yes, Judge. The officer did also tell me respectfully that we don't really have jurisdiction to litigate this immigration issue.
Sure. What you want is you do not want me to revoke his bond.
That is correct, Judge.
You want me essentially to hold this case open. He's going to get deported, right?
That is my understanding.
Essentially, what you want me to do is you want me to hold this case open indefinitely.
Judge, if I may.
Okay.
Look, to me, for this court to revoke its bond based on these circumstances, I'd like to constitutionalize the objection. I think it would be, a violation of equal protection, procedural due process. I think it would be a violation of Section 11 of the Texas Constitution, which say that all prisoners shall be bailable. Section 13, which say that excessive bail shall not be required. Section 19, which says that no citizen of this state, I don't think they mean US citizen, shall be deprived of liberty, which this would be doing by revoking his bond, without due course of the law of the land. Now, the Texas Code of Criminal Procedure is very clear. When a defendant has once given bail for his appearance, he shall not be required to give another bond. That's 17.09 paren 2. This defendant, all he has done is posted the bond that the state requested, and without any volition on his own, gets taken into ICE custody. I think you would agree with me, Judge. The state has the burden to prove a bond violation. There is a bond violation report. I think we should all agree there's been no bond violation because he had no ability to get an ignition interlock. He had no ability to report to pretrial. So the only exception to this one bond are the following. If the bond's defective, there's no defective in the bond. If the bond is excessive, nobody's arguing the $1,000 bond was excessive. If the bond is insufficient in amount, which is very broad, but I want to make clear that there is no amount of bond, as Ms. Saba just said, that can guarantee that my client can attend court. There's no amount. So I don't think insufficient in amount is correct. The only other catch-all is good and sufficient cause. Now, I did some case law research on good and sufficient cause, and these are new or changed circumstances from which the court can conclude that some cause exists for revoking a bond and setting a different bond. Now, as I said, the only bond that this court could set that would guarantee my client comes to court would be a bond that is impossible for him to post, right? Because any postable bond, he would have no control in getting to court. Now, ICE, if I may, Judge, I understand what Ms. Saba relayed that the ICE officer said, but I can tell you that 8 CFR section 241.5 allows ICE to release anyone on an order of supervision if they're subject to a final order of removal. If you look at Exhibit 1, the ICE detainer, it says that if you need this subject to remain in the United States for law enforcement purposes, you can call this number, and ICE can consider whether the law enforcement purposes are serious enough to keep the person in the country. Now, I think it would be punitive to take away $1,000 from somebody who posted a bond that this court affirmed, that the state requested, and say, I'm taking away your $1,000 because of actions completely out of your control, actions that are being taken by a third party.
So if I bench warrant him back here, then nothing will happen to that then, right?
A bench warrant is a revocation of bond. Because if you bench warrant him, basically you're asking the sheriff to go get him, or you're asking ICE to bring him. ICE has already told Ms. Saba, we're not bringing him. The sheriff, if they go recover him.
No, they haven't said they said they were going to think about it, that they were going to look at it. They didn't say that they weren't going to.
Well, then let me clarify, Judge. If you want to bench warrant and be clear in that bench warrant that this is not a revocation of bond, I have no objection to that bench warrant. It's my opinion.
You had an objection last time to the bench warrant.
I have thought about it some more, Judge. If you bench warrant him, but there's no revocation of bond, I have no objection.
Well, then we're all happy.
But
Are you happy with that?
Yes, Judge, I'm
Great.
fully deferring to you.
Let's do it.
then let me say one more thing, Judge.
Mr. Feldman urged Judge Fleer to issue a bench warrant instead of revoking Mr. Moses Perez's bond. He argued that his client's failure to meet the bond conditions was not willful. Mr. Perez had been detained by ICE and therefore could not report to pretrial services as required. As explained earlier, a bench warrant in this situation would serve as a formal request asking ICE to transfer Mr. Perez into Harris County custody so the criminal case could proceed. However, if Judge Fleer chose to revoke the bond in addition to issuing the bench warrant, the $1,000 bail posted on Mr. Perez's behalf would be forfeited to the state. At this stage of the hearing, it wasn't entirely clear why Mr. Feldman was so determined to keep his client's bond intact, but as the proceedings continued, his reasoning and strategy would soon come into focus.